You hit send on an email to a business partner in Berlin. What you don't know is that your partner is currently a target of the National Security Agency. Because that foreign contact is under surveillance, your email is intercepted in transit and stored indefinitely on an NSA server, all legally authorized under FISA Section 702. The government calls this incidental collection. Looking at this diagram of Section 702 surveillance, the large outer ring represents the foreign targets the law is designed to monitor, but that rapidly expanding inner cluster represents the hundreds of thousands of Americans whose personal data gets swept up into the exact same database without a domestic warrant. Intelligence agencies maintain that this collection is subject to rigorous oversight, yet repeated audits have documented the FBI running thousands of non-compliant warrantless searches on American citizens using this very system. To understand how so much domestic data is collected with such massive blind spots and accountability, we have to trace a piece of data through the system and look at the exact points where the oversight breaks down. The first checkpoint happens before your email is even collected, at the Foreign Intelligence Surveillance Court, or FISC. This is the highly classified judicial body that originally authorized the wiretap on your European business partner. The FISC operates through programmatic oversight. Instead of issuing individual warrants for specific targets, the judges approve broad annual targeting and minimization procedures for the intelligence community to follow. Because the approval is programmatic, no judge ever evaluated your specific email, your context, or your constitutional rights before your data was captured. At this first toll booth, the judicial review is entirely structural. It provides zero individualized protection for the American citizen caught in the dragnet. Eventually, your email makes its way from the NSA into an FBI database, where a domestic agent decides to type your name into the search bar. To curb historical abuses of these exact searches, Congress passed the Reforming Intelligence and Securing America Act, or RISA, in 2024. This flowchart lays out new hurdles for an FBI agent. They must opt in to access Section 702 data and secure attorney pre-approval for U.S. person searches. Afterwards, the Department of Justice must conduct an audit of 100% of these queries. But the FBI and the Department of Justice both answer to the executive branch. This process is executive self-policing, not an independent check by a separate branch of government. The second toll booth is an illusion. RISA legalized a system of internal compliance while completely bypassing the constitutional requirement for a judge's warrant. Let's say you discover this warrantless surveillance and decide to sue the government, seeking a judge's review of your specific case. In the landmark Supreme Court case, FBI v. Fazaga, a group of citizens tried exactly this. They attempted to use FISA's own statutory rules to force a trial-level court to evaluate the legality of the surveillance against them. In response, the Department of Justice deployed the state secrets privilege, arguing that the litigation would expose critical counterintelligence information and harm national security. The Supreme Court ruled that FISA Section 702 does not displace the state secrets privilege. The government retains the power to demand dismissal of the claims without the plaintiffs ever seeing the evidence. At the final toll booth, a citizen explicitly asks for individualized judicial review, and aggressive government lawyering, combined with the state secrets doctrine, permanently shuts the courtroom doors. This balance scale visualizes the core structural mismatch legal scholars have identified. Congress delegated programmatic review to the judicial branch, which is ill-equipped for broad policy approvals, while the executive branch locks away the individualized review that courts are actually designed to perform. The intelligence community is currently facing a ticking clock. The RISA reauthorization of Section 702 includes a strict sunset date of April 20, 2026. That looming expiration acts as a forcing function. It gives lawmakers a mandatory deadline to dismantle and rebuild this broken oversight regime. To fix the structure, Congress must reclaim the responsibility of programmatic oversight for itself and direct the FISC to perform individualized reviews on specific uses of the authority. Until that mismatch is corrected, Section 702's privacy safeguards are a constitutional illusion. The system functions only as well as the government's willingness to police itself in secret.